Police just kicked in your door without a warrant. Was it legal? The Fourth Amendment protects against unreasonable searches and seizures. A search without a warrant is presumptively unreasonable. It is only valid if an established exception applies. Warrants must be supported by probable cause. They must describe the place and items to be seized with particularity. The first exception is exigent circumstances. This permits warrantless entry when police must act immediately. Exigency exists to prevent the destruction of evidence. It also protects life or prevents a suspect's escape. Hot pursuit of a fleeing felon is a key example. The scope of the warrantless search is strictly limited. It must match the exigency that justified the initial entry. Police cannot deliberately create the exigency. This prevents bypassing the warrant requirement. Hot pursuit allows police to enter private property without a warrant. This applies if they are immediately and continuously pursuing a fleeing felon. The pursuit must be immediate, not merely a delayed investigation. The Emergency Aid Doctrine permits warrantless entry for safety. Police must reasonably believe a person inside is injured or in imminent danger. This standard is objective, focusing on a reasonable officer's belief. The officer's subjective intent is irrelevant to the analysis. The justification for the warrantless search ends immediately upon resolving the emergency. Police must then stop searching the premises. Any evidence observed in plain view during the lawful emergency entry may be seized. This seizure is permissible under the Plain View Doctrine. A lawful custodial arrest automatically permits a warrantless search. This is known as search incident to lawful arrest, or SILA. SILA is justified by the need for officer safety. It also prevents the destruction of evidence by the arrestee. Police may search the arrestee's person entirely. They may also search the area within the arrestee's immediate control. This area is often called the wingspan. It includes places where the arrestee might grab a weapon. It also covers areas where they might conceal evidence. When an arrest occurs in a vehicle, the rules change. Police may search the passenger compartment only under specific conditions. Under the Gant rule, the arrestee must be unsecured and within reaching distance. Alternatively, police must have probable cause that evidence related to the crime of arrest is present. Importantly, SILA does not permit searching digital content. This applies even if a cell phone is seized during the arrest. A warrantless search is valid if police obtain voluntary and intelligent consent. The consent must come from a person with proper authority. Voluntariness is determined by the totality of the circumstances. Factors include the consenter's age, education, and police conduct. Police are not required to inform the individual of their right to refuse consent. Consent can be given by anyone with actual authority over the premises. This includes a joint occupant of the property. Apparent authority exists if the officer reasonably believes the consenting party has the right to permit the search. This belief must be reasonable, even if the party ultimately lacks actual authority. If co-occupants are present and disagree, the objecting party's refusal controls. The scope of the search is strictly limited. It cannot exceed the scope of the consent granted by the authorizing party. Police may seize evidence without a warrant under the Plain View Doctrine. 3 specific requirements must be met for this exception. First, the officer must be legitimately on the premises. They must be lawfully positioned to view the item. Second, the item must be immediately apparent as contraband or evidence of a crime. Third, the officer must have probable cause to believe the item is incriminating. This probable cause must exist without conducting any further search or manipulation. The Plain View Doctrine only justifies the seizure of the item. It does not justify the initial entry into the protected area. Analogous doctrines also exist for other senses. Plain feel applies during a lawful Terry frisk for weapons. Plain smell applies when an odor provides probable cause for a search. Police may search an entire vehicle without a warrant under this exception. They must have probable cause to believe the vehicle contains contraband or evidence of a crime. This exception is justified by the vehicle's inherent mobility. It is also based on the reduced expectation of privacy in automobiles. The search can extend to any part of the vehicle. This includes the trunk, glove compartment, and all containers inside. The evidence must reasonably be locable in the area searched. The scope is defined by the object of the search. Police may search anywhere the item could logically be hidden. If probable cause exists to search a specific container placed in the car, police may search that container. This is true even after the container has been removed from the vehicle. Police may briefly detain an individual known as a Terry stop. This requires reasonable suspicion supported by articulable facts. The officer must suspect that criminal activity is afoot. Reasonable suspicion is a lower standard than probable cause. If the officer reasonably believes the person is armed and dangerous, they may conduct a frisk. A frisk is a limited pat-down search strictly for weapons. It is not a general exploratory search for evidence. The search must be limited to the outer clothing. If the officer feels an object during the frisk, they may seize it. This is permissible if the incriminating nature is immediately apparent. This seizure falls under the Plain View Doctrine. The duration and scope of the stop must be limited. They must not exceed the justification for the initial stop. Administrative searches target highly regulated industries. Examples include liquor sales or mining operations. These searches require no individualized suspicion. The search scheme must be necessary and defined by statute. Special needs searches are conducted for non-criminal purposes. The primary goal is not gathering evidence for prosecution. Examples include border searches and mandatory drug testing of certain employees. Fixed-point sobriety checkpoints are also considered special needs searches. These searches balance the government's special need against the individual's privacy interest. These exceptions bypass both the warrant and probable cause requirements. This is because the primary purpose is regulatory or safety-related. The scope of these searches must be narrowly tailored. It must address the specific non-law enforcement need.